Hello, my name is Lauren Bavitz Fields, and I'm a family law attorney on the domestic litigation team at Roth Davies LLC. Today I'm going to be talking to you about child custody. Often I get a lot of questions from clients believing that joint legal custody means that they have 50-50 time, and that is simply not true. In Kansas, there are three types of custody. There's legal custody, there's residential custody, and then there's parenting time. Let's talk about joint legal custody. That is the presumption in Kansas where both parents are able to have equal decision-making in medical and legal decisions for the child. This involves schooling, this involves if their child needs to go to the emergency room, this is involving any kind of religious decisions about the child. In Kansas, the presumption is that both parents have joint legal custody. You can request that the child have sole legal custody, but that is very difficult to do in the state of Kansas. You have to overcome the presumption that joint legal custody is for the best interest of the child. Sole legal custody would only be appropriate in circumstances where the parent is unable to make those legal decisions for the child due to a substance abuse order, perhaps incarceration, etc. Now let's talk about residential custody. Residential custody is which parent will have the child stay at their home for the majority of the time. You can have 50-50 residential custody if you can prove that it's in the best interest of the child. Oftentimes, the residential custodian is the parent that typically spends more time with the child, is the parent that takes the children to doctors' offices and school. 50-50 residential custody is sometimes in the best interest of the child, but both parents need to have a very cooperative relationship. They need to be able to see each other almost on a weekly basis and not have the child's schedule disrupted by consistent changes in the schedule. The last type of parenting time is parenting time for the non-custodial parent. So assuming mom or dad is the residential custodian, we need to determine a parenting time schedule for the non-custodial parent. Often, depending on your jurisdiction, there are family law guidelines which dictate a de facto schedule for the non-custodial parent. Shawnee County, for example, has one. Douglas County, Johnson County will have parenting time guidelines to say, absent an agreement, the de facto parent should have X amount of parenting time. There are also parenting time schedules for holiday time, depending on your jurisdiction, and vacation time. You should contact a local attorney to determine whether these family law guidelines are appropriate for your case or whether you need to attend mediation or go through your attorneys to determine what that parenting time schedule should look like for the non-custodial parent. If you have any questions about child custody, please feel free to contact us at Roth Davies at www.rothdavies.com or by telephone at 913-451-9500. Thank you.